U.S. Supreme Court Justice Amy Coney Barrett giving the state of Illinois till December 6th to respond to plaintiffs out of the Naperville case, bringing an emergency appeal to the U.S. Supreme Court. That is breaking news today. That's the second such case challenging Illinois' gun and magazine ban that the U.S. Supreme Court has put on the docket. So let's go ahead and check this out. If you go to the Supreme Court's website, you can search the docket, and just merely searching Illinois, you'll be able to find the case that was actually docketed earlier this week. But you have the case in Naperville, National Association for Gun Rights versus the City of Naperville, docketed November 29th. So again, that was actually yesterday after it was filed on the 27th. And then today, you have Justice Amy Coney Barrett ordering a response from the state by December 5th. So ultimately what you have is a request that the U.S. Supreme Court come in and handle this. And it's a request that we've seen before when the Naperville plaintiffs were trying to get the emergency injunction in place after the Northern District issued a order saying that the state was in the right. And you had, of course, them going to the appeals court asking for an emergency injunction while the case played out. The appeals court denied that. But you then had the plaintiffs in the Naperville case go to the U.S. Supreme Court then before the Seventh Circuit actually consolidated cases from the Northern District and the Southern District into a case they heard, if you recall, weeks ago, and took them 4 months or more to actually rule on that back in August, the three-judge panel from the Seventh Circuit U.S. Court of Appeals. But if you look at, again, at the Supreme Court docket from today, where Justice Amy Coney Barrett gave the state till December 5th, December 6th to respond. You've got the document here that the plaintiffs put in spelling out why they believe that this is warranted. And they go through and cite the background, and then they lay out all of the various aspects as to why they believe the three-judge panel got it wrong. And they say that the three-judge panel, they ultimately said that the court held that the plaintiffs failed to demonstrate the act is likely unconstitutional. They note that the banned firearms and magazines are in common use for lawful purposes, and the act is clearly unconstitutional. They go on further to say that 7 different things that the appeals court got wrong. They said the court held that banned firearms are not even arms covered by the plain language of the Second Amendment. The court wrote that the common use test is the product of faulty circular reasoning and cannot be usefully employed in this or any other case. They went on to suggest that Bruin's history and tradition test is hypothetical. They argue that the Seventh Circuit's majority failed to apply Bruin's history and tradition text in a meaningful way. They argue that the appeals court held that any arm may be banned if a judge thinks it's particularly dangerous, and that the court's decision rests on stealth interest balancing. And that's one of the things that the Bruin case really seemed to put to rest is you can't use balancing public safety with constitutional rights. It went on to say also that they argue the appeals court held that an arm may be banned merely because it's similar to a weapon used by the military. And they say for that reason, they're being essentially irreparably harmed. And you see that here where they say citizens are suffering irreparable injury because their fundamental rights to keep and bear arms is being infringed. And they respectfully urge for the Supreme Court to intervene. So that's the latest in the case that the U.S. Supreme Court apparently now has docketed out of Naperville. So you still have plaintiffs in the appeals court asking for a full appeals panel to rule on that. But you also have down in the Southern District, December 12th, being the case that federal firearms licensees of Illinois are asking for the lower courts there to enjoin the state from enforcing that January 1st gun registry deadline. But that wasn't the only thing today. Also, some breaking news. The Illinois Supreme Court issued a ruling against releasing FOID card information to individuals requesting through the Freedom of Information Act their own FOID card information. So you remember that case was back in September when they brought that forward. Another interesting case that popped up on us here on this Thursday. So I wanted to break in outside of doing the morning show live, and we'll talk more about this again tomorrow, but wanted to get that information out to you on the quick. All right, it's Bishop on Air. Like, subscribe, follow along, and you can keep up to date with what's going on with Illinois' gun ban and all the litigation that there is around it, because there's tons of it all around it. But again, big news here. Justice Amy Coney Barrett considering a case that ultimately has some ramifications on whether or not the U.S. Supreme Court's going to intervene or whether or not they're going to, not intervene. But the state has until December 6th to reply. And this is the second case out of Illinois the U.S. Supreme Court has docketed. And you have that case from Dan Calkins where he's alleging conflicts of interest from the Illinois Supreme Court, where you had two justices when they were candidates getting $1 million plus from named defendants on the challenge against Illinois' gun and magazine ban that the Illinois Supreme Court did not recuse those justices and ruled against the plaintiff. So that is also in front of the U.S. Supreme Court. A lot of moving pieces. Hopefully we can boil it all down and distill it for you to better understand what's going on. All right, that's the latest for you. I got to get out of here and get back to work, guys. All right, have